All right, all right. So perhaps you have inherited a property, or you have your executor for probate, or the administrator for an estate probate that's taking place in North Carolina, and you're wondering when you can sell the property. Maybe you need to unlock some of the inheritance to share with other heirs, or perhaps you need to pay for some of the debt that's in the estate, or maybe you need to pay for the attorney that you're using for the probate, or maybe some combination or other outside factor. But you're trying to figure out when you can, or if you can, sell a property before it goes through the probate process in North Carolina, and particularly if it does not have a will. That's what we're going to talk about today. What's going on? I'm Courtney Rollins, the Life and Transitions property expert in Life and Transitions YouTube channel, host, moderator. Facebook group is also a space where you can find us and see other folks who are committed to helping folks through the biggest transition in life, particularly solving problems and issues when it comes to real estate and helping people generate income and sometimes wealth with that. But the most important thing is solving those challenges and issues. So we're looking at today that big question: can you in North Carolina sell your property before it goes to the probate process? And I'm going to ahead and let the cat out. Well, I'll start like I say at some point to almost all of my content. I am not an attorney. And I'm not giving financial legal advice. I'm just sharing my experience as a property cash buyer, as a probate specialist, and as someone who genuinely wants to help you succeed and help you solve the challenges that you may have. All right. So but the short answer to that, from my experience, once the property is inherited, you can sell the property. It's just like any other normal real estate transaction. You just everyone who's the heir needs to sign off. That's the short answer. Now, again, consult an estate professional, particularly a real estate attorney and or a financial advisor, so you can know the implications that will come along with selling it. But yes, you can sell a house before it goes through probate in North Carolina. In fact, in most cases, property is not considered a probate asset in North Carolina, unless the will specifies that it has to be sold, or specifies that it can or needs to be sold to for different stipulations like paying off bills and all. But let's take a little deeper look and check it out. All right, so um, and shout out to Denise Harper, who's also a probate specialist, a real estate agent and investor, because I do tons of content, and I saw, and I was looking up, researching, and I saw her YouTube channel, and she had similar information up here and a great article about this. So I just wanted to shout out to her because this is an awesome service that she provides in helping people figure out, you know, you know, how to navigate those waters. All right. And so let's just say if it is a property and there's will and it's already inherited, it's already going through the people, it's just like a normal real estate transaction for the most part. All the heirs need to sign off. Now, if someone dies testate, that means they have a testament. They have a will that they left behind is valid. That's died testate. That means the person will go through the will actually has to still go through probate. That's how you execute the wishes and suggestions of the will, and you have a letter of testamentary. Someone's an executor they're executing those wishes. Intestate means that they passed away without leaving a valid will, and so that is left to intestate law. So when a person dies without a will, the property may be divided between the surviving spouse, children, and there's a whole chart. And definitely check out. You can either just Google North Carolina intestate law, or reach out to me and look at some of the past articles and videos I've done explaining that. But there is a order of who the stuff will be distributed to. Now, if you do want to sell the property, or I already gave this disclaimer about sharing my experience and my ideas, not giving legal financial advice. But if you do want to sell the property when there is no will, you usually will need to have the notice to creditors to be already placed during the probate process. There has to be a way for anyone who has a claim against the estate to have the proper amount of time to make that claim, and that's the notice to creditors. It has to go to a vetted publication that has a certain circulation, so that people have a good chance to share. Um, but once you actually place that, it's run at least once. At least the closing attorneys I work with, it has to only run one time in the ad. Then if other things are on board, you can go ahead and sell the property. Um, it is now notice creditors does have to run for basically 4 months. It'll have to run for 4 consecutive weeks. That's 4 weeks in the paper, and then 3 months after that is when people have the opportunity um, to submit their claims. So it runs in the paper for 4 consecutive weeks. So that's a month, and then 90 days after, up to 90 days after that last um, posting is when creditors have the opportunity to share and state their claim. We'll go through all this. Air affidavit, renunciation of beneficiary, receipt of benefits, and transferring title as needed. So we talked about notice of creditors, getting it to the news publication. Um, you also will need to fill out some type of heir affidavit to show who is the heirs, and it could be something as simple as this. You can Google one, reach out to me, and I can send you one that you could fill in as a Word document. Or, but basically, it's showing who's still alive, who has a right to the property, who's passed away, who had a right to the property, who are their children or their spouse, and you'll get this notarized so that it's and witnessed so that the closing attorney can show that, hey, this is the person who has the right to it, and these are the people who have the right to the property. Now, if there's anybody who does not want the proceeds from the sale or does not want to have to sign off on selling it, then you can have them submit a renunciation of beneficiary. That means that they state this is the asset that I have heirship to, and I'm saying I don't want it or I only want a portion of it or whatever the details are. You'll have that written up so that and again, I would recommend you have that notarized. And I don't know if it has to be notarized, but I'm sure it would need to be notarized, but at least witnessed so it can be validated, self-proving. Also, once it's sold, I highly recommend that if you are, well, once it's sold, you need to have people sign off that they received a portion of the benefits that was going to go to them, and make sure that's recorded and keep a record of that as well. Now, if it's a car or other things, you will need to have the title properly transferred over. If you're doing this if you're selling the property, then the closing attorney will take care of all of that. All right, so there it is. If you need any support with state services or any type of services that relate to probate or estates or really any transitions in life, definitely reach out to me at 919-341-1992 or Courtney at estateproservice.com. And I would love to support you, love to help you out. I'll be doing another article or piece of content tomorrow about why somebody may decide to sell. I mean, it's great to keep properties, to hold on to them, but that's not the situation for everyone involved. So tomorrow, I'm going to post something about 7 reasons that you may want to sell to a cash buyer. And if you find yourself in that situation, definitely reach out to me because I'll definitely be able to support you. All right. Would love for you to hit the like. Would love for you to hit the subscribe. Share any suggestions or any content you would like me to cover, and we'll make sure to do our best to do so. This is the Life in Transitions Experts YouTube channel and podcast and Facebook group. Let your light shine. Cheers.